Our final panel today is entitled Departmentalism of Government Efficiency in the Administrative State. We are saving administrative law for the afternoon, but we're going to make it, we're going to make it great again. President Trump's DOGE initiative, we'll get it covered. President Trump's DOGE initiative, in which Elon Musk has been heavily involved, has been one of the most heavily politicized policy initiatives of his administration. From widespread reductions in force across federal agencies, to termination of billions of dollars in federal contracts, to efforts to reduce or eliminate agencies of government, these DOGEcrats have taken Washington, D.C. by storm. But less clear is how DOGE fits into the modern administrative state. How is it organized? Are DOGE personnel agents of the president, congressional auditors, or something else entirely? And how do DOGE reforms challenge the status quo, where unelected bureaucrats have long staffed agencies across administrations and implemented their own policies rather than that of their elected leaders? Our panel today will help address these very important questions. And our panel today will be moderated by the Honorable Douglas R. Cole, United States District Judge for the Southern District of Ohio, who will introduce our panelists. Judge Cole is a graduate of the University of Chicago Law School and clerk for Judge Frank Easterbrook on the Seventh Circuit U.S. Court of Appeals before practicing at Kirkland and Ellis, acting as a professor at Ohio State, serving as Ohio State Solicitor, which was the position before they created the Office of Solicitor General, where he argued 5 cases before the Supreme Court, serving as a partner at Jones Day in their issues and appeals practice, and then finally practicing at his own litigation boutique, Organ Cole. Judge Cole was nominated to serve on the district court by President Trump in 2019, was confirmed and took a seat that year. We're honored to have you, Judge Cole. The floor is yours.
Thank you very much. Yes. I'd like to start by, thank you. I'd like to start by thanking the Federalist Society for putting together an outstanding program throughout the day, but also for asking me to moderate what should be a truly interesting discussion with a fabulous panel. That panel includes, from the end down there, Professor Susan Dudley. She's the founder and former director of the George Washington University Regulatory Studies Center, which is focused on improving regulatory policy through research, education, and outreach. She's also a distinguished professor of practice at the George Washington School of Public Policy and Public Administration. Perhaps most on point for the current panel, from April 2007 through January 2009, she served as the presidentially appointed administrator of the Office of Information and Regulatory Affairs, which is frequently called OIRA, in the United States Office of Management and Budget. Then we have Ben Flowers, who is a partner at Ashbrook, Byrne, Kresge & Flowers. Before joining the firm, he served as Ohio's 10th Solicitor General for 4.5 years, where he argued 3 cases in the United States Supreme Court and a bunch more in the Ohio Supreme Court and Sixth Circuit Court of Appeals. He's also worked in the Issues and Appeals Group at Jones Day. He's a graduate of the Ohio State University and the University of Chicago Law School, and clerked on the Ninth Circuit for Judge Sandra Akuta and at the Supreme Court for Justice Antonin Scalia. And last but by no means least, Professor Bridget Dooling, who is a nationally recognized expert on administrative law and regulatory policy at the Moritz College of Law at The Ohio State University. There she has published broadly at top journals, including the Duke Law Review and the American University Law Review, just to name a couple. She's also a senior fellow at the Administrative Conference of the United States, and prior to joining the faculty at Ohio State, she was a research professor at George Washington University Regulatory Studies Center and at George Washington Law School. And like Professor Dudley, she also spent time at OIRA in the OMB. I also know from personal experience she's a talented Texas Hold'em player, but that is a topic for another day. There's, the topic DOGE covers a whole lot. You may not even heard of it, right? It's barely, there's this guy, Elon Musk. I don't know if you've heard about him, but it covers a broad range of topics. And so I think people are going to have different takes on it here. What I intend to do is give everybody sort of 5 to 7 minutes for opening statements, and we'll have some engagement among the panel. And at the end, there'll be some time for questions. But I think you'll see that everybody has a slightly different focus point when we start out. So we're going to start out with Professor Dudley, who I think is going to talk a little bit about what DOGE has promised with respect to deregulation. How feasible is it? As you know, we've all seen Elon Musk waving that chainsaw around. There's sort of this idea that there's too many employees, too much money, too many regulations, and I think he's talked about what DOGE could do with respect to that, but Professor Dudley is going to talk a little bit about the deregulatory aspect of it. So Professor Dudley.
Yeah, that's right. I'm not going to talk about chainsaws or the weekly emails that staff now need to deliver on the 5 things I did this week. I'll leave that to the others on the panel. But my focus is regulation and deregulation, and there's plenty going on there, as the judge said. So just to give you my bias, I think I've studied regulation for a long time, and I think there is room for regulatory reform. That there's excessive regulation and it drags down the economy. But one of the questions I have is, how do you deregulate, and is it sustainable what they're doing? It's not as easy as signing executive orders or, well, I'm not sure how easy it is to eliminate an agency. So let me just walk through the ways there are to deregulate, from the quickest to the most time consuming. So the first is and every president does this, when they first get in office, they just stop the presses and say, don't send any more regulations to the Federal Register until the new team gets to look at them. They also might delay one at a time the effective dates of regulations that have been published but aren't yet effective. The Congressional Review Act, which if you're interested in, I would happily talk more, but there's a limited window for regulations issued after August 16th for Congress to issue a resolution and disapprove those. And if you're interested in that, the Regulatory Studies Center has a dashboard that can show you which regulations are eligible for that, which ones Congress has already proposed to disapprove, and which ones have been signed. The third is the stance they take in litigation for regulations that are final and that have been litigated. How the Justice Department handles those could affect the final outcome of those regulations. How they enforce regulations, and there's a lot of talk about that, and I think I defer to Ben and Bridget and the judge on how successful and kind of durable and certain that would be. But then the other thing is, for every regulation that was issued through notice and comment rulemaking, you need to go through those same steps to deregulate. And that takes time. So certainly much longer than DOGE's window of 1.5 years that it's given itself to eliminate regulations and shut itself down. So that brings me to the Office of Management and Budget, Office of Information and Regulatory Affairs, or OIRA, which Bridget and I are both very familiar with. It's a small staff of mostly career people in the executive office of the president, in OMB. Managing the administrative state is challenging, and so presidents since 1981 have given this office responsibility to make sure that the White House has some oversight, some control over the agencies. So they're career officials, so they bring this institutional knowledge. They work closely with all the new political appointees in the West Wing, but they do have that institutional knowledge, as well as a cross-cutting perspective. So agency heads, politically appointed agency heads, can very quickly get captured by the agency. And having that office, I mean, we've already seen clashes with Musk. Having that office there that has that cross-cutting perspective is valuable. And of course, they know that process. The notice and comment process especially is something that OIRA is involved in day to day. So looking at Trump's actions so far, he does have DOGE working with OIRA. He issued initial executive orders that rescinded orders that President Biden had issued. I think he's issued I don't even just have to say I think. I know he's issued significantly more executive orders in his first few weeks of office than any president had before. Bridget will know this, but I think President Biden had the record before, and Trump certainly does now. So some of those initial orders were to be expected, revocation of Biden's. Interestingly, though, he did not revoke President Clinton's 1993 executive order that guides OIRA review, that provides that framework for review. He did revoke President Biden's amendments to them, and Biden President Obama had revoked Bush's amendments to them, but that order stays in place. He also revoked President Biden's guidelines on regulatory impact analysis, and if you ask me to talk about that, I will bore you for the rest of the day, so I won't. But I will tell you that the Federalist Society is doing a webinar on that on April 23rd. So if you're interested in that, there's more coming. We've all heard about the 10-for-1 executive order. For every new regulation, agencies have to eliminate 10. That's kind of gimmicky. It's getting the most attention, but how you count regulations matters a lot. And so if it's apples and oranges, we may be able to count up 10-for-1, but it may not have a very big impact. The other part of that order, though, is an incremental regulatory budget that each agency has to issue, that all their regulations have to have a net cost that is less than zero. And that is likely to be more binding. It was in the first Trump term, more binding than the 2-for-1 order. Although I think if it's like the first term, even that is more likely to slow the pace of new regulations than to dig into regulations that are already in existence and remove them. He also issued a DOGE executive order that specifically focused on regulation that directed them to work with OIRA, with OMB, and to review regulations with an eye towards rescinding those in two general categories. One is those that have costs that exceed their public benefits. So that's the OIRA lens that I'm very familiar with, that benefit cost analysis. And the second one is implicitly a LOPR lens. It directed them to identify unlawful regulations that undermine the national interest. So I think that's going to be very interesting to watch. I think LOPR will work both ways on that. On the one hand, they can look and say, these regulations we think aren't clearly directed by the statute. But on the other hand, I think the majority was pretty clear in that opinion that regulations that have been, interpretations that have been around for a long time are probably won't be reversed. So I think we'll see less flip-flopping and whipsawing between administrations as each administration reinterprets the same statutory language to mean something different. Another interesting thing to me, and I think to Bridget as well, is a recent executive order that requires independent regulatory agencies like the Federal Trade Commission or Consumer Product Safety Commission to go through that OMB review that's been required since 1981. There are certainly constitutional arguments that independent agencies are part of the executive branch, and I will defer to everybody in this room who knows more about that than I do. But there has been bipartisan support. I guess we didn't mention, I'm not a lawyer. That's why you all know more than I do on that. It's probably been obvious by what I said anyway. But there has been bipartisan support for independent agencies getting better review. And from my perspective, I think it's valuable because there's evidence that the analysis that they've done to justify their regulations has been weaker in general than the agencies who have to get that OIRA, have to go through the gatekeeper of OIRA. So looking long term, coming back to my point about durability, I don't know if the DOGE teams really appreciate the processes that are involved in deregulation. They've got to do their homework. They've got to be able to justify their decisions on legal grounds, but also regulatory impact grounds, or or they won't survive in court. I also, my last point is that they need to get the legislative branch involved. Right now, it's kind of a do-it-alone approach, and President Biden, too, had his whole of government concept, which really meant whole of the executive branch. The executive branch really needs support from the other branches. So I think there should be an equivalent of the Congressional Budget Office that focuses on regulations.
Thank you. Well, now we'll get, I think, a somewhat related take. Bridget's got a very similar exposure to OIRA and things, but also, unlike Professor Dudley, just outed herself as a non-lawyer, right? Bridget is a lawyer. So Bridget, kind of what's your take on what exactly DOGE is, and sort of how does it fit within the existing administrative law framework that we have? How should we understand what its role is from, how does it interface with OMB, OIRA? Is it something different? Where do you see it fitting in?
Yeah, thanks, Judge Cole. First, let me say thank you for having me. It's my first time at the Ohio chapter's gathering, and it's a pleasure to see so many current and former Buckeyes here. So great to see you, and I hope as the years go on, if you have me back, that number of faces I recognize in the room will just go up and up. But really is a pleasure to be here. I come at this question from a background of being a longtime civil servant. I was a civil servant for almost 15 years, over 10 of which were at the Office of Information and Regulatory Affairs, which is an interesting kind of civil service job because you are looking out over the entirety of the federal government. So not so much just sort of working on one narrow, expertise-driven program area, but really a big cross-cut, across the federal government. So that's kind of how I come to this. I also come to this in my capacity as a scholar and just trying to observe, what is happening compared to what we might have expected, and of course trying to think about its implications for things like the rule of law. So I guess I want to start by talking about the importance of focusing on the DOGE we actually have versus the DOGE that we might have been promised, right? There was that famous op-ed by Ramaswamy and Musk in the Wall Street Journal that articulated a vision for DOGE that echoed some similar themes to what we've seen presidents argue for in the past. The idea of running on a platform of cutting waste, reining in excess. I mean, these are cutting red tape, right? These are presidential campaign themes that have been part of every presidential campaign that I've been aware of in my lifetime, right? And certainly before that as well. So to some extent, in hearing about this concept of DOGE, other than its absolutely ridiculous name, right? It's clearly sort of trolling you with the name from the jump, which is, you can sense the Musk influence on that immediately. Still, we were sort of saying like, all right, there's been a lot of prior talk about this type of energy coming into government, new sheriff in town. We're going to see what we can cut and make government better in many different types of visions of what better means. So with that blueprint in mind, I gave this quote on January 22nd, which I'm going to read to you, basically to establish that my crystal ball is no better than anyone else's. The reporter Will Oremus asked me for the most realistic best take for DOGE, and then the most realistic worst case for DOGE. He writes for the Post. He does one of their tech newsletters. So realistic best case. They work with the rest of government rather than against it. This isn't going great so far. There are lots of people in government who want things to work better, and this new DOGE will help itself by not positioning itself as opposed to the entirety of how government works and the people in it. All right, swing and a miss on the best case from my perspective. Realistic worst case. They spin their wheels, waste a bunch of money and other people's time, reinventing policies that have already been tried, start fights in public and private about things where their knowledge is limited, and work at cross purposes to other more knowledgeable parts of the executive branch. So I think of the two, probably my second take was the more accurate, but it does nothing to come even close to sort of how we've seen DOGE act in reality, right? But I think that's because I, like many people, was working from a frame of like, what have presidents generally done when they come in and try to modernize government? We've seen lots of different versions of this, sort of presidentially led initiatives to cut red tape, to modernize, to do things to sort of bring the bureaucracy up to modern standards. And yet, we saw unleashed, I think it's fair to say they were unleashed, DOGE upon federal agencies. They didn't quite do the things that Susan described, that their EO directed them to do. If you thought about that, then perhaps you'd think they'd be behind the scenes, working with OIRA on deregulatory proposals, helping agencies figure out how to identify, say, the most wasteful regulations to cut. But instead, we've seen them lock civil servants out of server rooms, commandeer entire federal agencies and buildings, direct the layoffs of thousands and thousands of federal employees, freeze money, cancel leases. This is not a moderate presidential initiative to reshape government. If any of this is news to you, by the way, I would encourage you to scrub in and read the details, right? The extent to which DOGE has been involved in a lot of these cuts. And maybe that thrills you. Maybe you thrill to this, right? You're like, burn it down, right? What do we have when it's left? I'll get to that in a minute. So that's the DOGE we've got, right? Not the sort of lofty blueprint-based vision that we might have had of DOGE coming in, or at least that I had coming out in the beginning. I think the next point I want to make is that it's really not just DOGE. The DOGE is not some reckless actor out there doing things of its own volition, right? It is very much under the control of President Trump, and it is being enabled by others in the administration who support its vision. So the extent to which some of the portrayals of Musk are that he's kind of out on his own, doing his own thing, I don't think that holds up. You don't learn how to fire civil servants unless you're enabled by legal counsel at OPM. You don't cut federal spending unless the people at OMB have your back, right? So there's a lot of internal infrastructure supporting DOGE, and so I would just push back on the idea that this is sort of just Musk being Musk, right? To some extent, he's the face. He's been described as a heat shield for some of this activity. I think that's an interesting theory. I guess my interest as a scholar and as an observer of this is understanding a bit more about who's really driving and what type of systems are really driving the decisions that DOGE is executing. But it's definitely not just DOGE. Right, so this calls into questions ideas of executive power to terminate payments, grants, et cetera. There's legal questions there, and a lot of them are in court, right? We've seen dozens at least of suits initiated to challenge whether DOGE has the authority to do this, whether agencies generally have the authority to do this, and it's just frankly too soon to call how all that's gonna turn out, right? We're only here in early April. It's gonna take a while for those suits to come to some kind of conclusion. Now, it would be a mistake to take from my remarks that I'm not sympathetic with ideas about reforming the government. It is too hard to hire federal employees. It is too hard to fire federal employees. There is waste in government. There is also something called services. And so if you thought you were building a government that would provide for, say, support for early childhood educations, and perhaps you even drop your kids off at certain early childhood places, daycares and other kinds of centers that support preschool. And then it turns out that you never knew that they got funding from Head Start. You go to drop your kids off, that funding's gone, you can't drop your kids off, right? So there's an invisibility to the way that the federal government shapes a lot of the services that we enjoy. And you can say, too bad, burn it down, right? We're gonna start over. My question for you is who pays the price in the meantime, and are they in this room?
Thank you. And then, Ben, I think you're going to give some thoughts on sort of what DOGE is and how it fits within the executive. And, a question one might ask is, Elon Musk is in charge of it. Is he acting as an officer of the United States? Was he subject to the Appointments Clause? Any thoughts on that question and sort of how DOGE fits in from an administrative law and constitutional law standpoint into the executive branch?
Yeah, I'm skeptical. Well, let me first lay out how I see DOGE, at least in theory, fitting into the equation of what it can do, and why I think it's much of what it's doing is constitutionally permissible and even vested in the president, and then pivot to some of that. And I want to start off I lost the program, but I think the first word is departmentalism. And so let me start by defining that, because I'm a departmentalist, and explain why I think it's relevant here. So there's this abhorrent view that you hear from many in politics, because it's convenient for them, that they act as though the Constitution means whatever the Supreme Court or a court says it means. So they'll say things like, well, I don't know if it's constitutional, but we'll pass it and we'll find out and we'll see what the courts say. That's appalling. Every single state and executive and judicial officer, whether state or federal officer, whether they're executive, judicial, or legislative, takes an oath to the Constitution of the United States. They're constitutionally required to do so. And when you take an oath of fidelity to the Constitution, it means you have to be faithful to the Constitution, even if you're not going to get caught if you get it wrong. Right? It's like the opposite view is like saying your marriage vows don't really matter as long as your wife doesn't find out that you're running around with someone on the side. That's absurd. It's equally absurd when legislators take the same view to their duty of fidelity to the Constitution. So what that means is that every time a legislator passes a law, every time the president enforces a law, every time the president brings a prosecution in a court, they have an independent duty to determine whether what they're doing is constitutional. If the president believes a law is unconstitutional, he cannot charge someone with a crime under that law, even if the Supreme Court's upheld the law. I don't care. He has an independent duty to adhere to the Constitution. Now, of course, the other branches have a duty under the Constitution to follow the judgments that courts issue. So if a court enjoins you from undertaking a certain act, you have to respect that. But what you don't have to do is recognize the holding of that case the next time the same issue comes up. So the famous example of this is Lincoln and Dred Scott. All of you know Dred Scott was a horribly wrong decision about the rights of blacks in America issued by the Taney Court. And Lincoln, when the Lincoln-Douglas debates, explained, I would be bound as president, or any president would be bound to respect the judgment of the court. So with respect to Dred Scott himself, the individual at issue in that case, I couldn't just ignore what the court said. That would be a violation of the Constitution. But I also have an independent duty to apply the Constitution as written, and because that decision's wrong, I'm not going to respect it except with respect to that particular person and that particular judgment. And he was right to say that. And so what that means is the president has a duty to apply the Constitution, and that means the actual Constitution, not the one that Anthony Kennedy's rectally extracted, or Brennan, or whoever else. Go all the way through. I mean, you've had a handful of acceptable Supreme Court justices. So he has an independent duty to do that. So what does that mean? Let's look at what the president's powers are. First, and I don't want to get into the details of Humphrey's executor and stuff right now, but I'll just assert, and we can talk about it later, that the president has the ability to fire without cause anyone wielding executive power. So that doesn't mean that everyone who works in an executive office is necessarily doing that. The person who works at the cafeteria and treasury is probably not wielding executive authority. But those who actually wield executive authority, he has the ability to get rid of. The reason for that is Article 2 of the Constitution vests the executive power not in a branch, but in a president of the United States, all of it. The Supreme Court's made some exceptions that it's continuing to narrow, and I think we'll soon abandon. We can get to that later. But by and large, the president, even now, has the power to fire individuals exercising executive authority, or at least officers doing so. And so what that means is when you get to DOGE, and DOGE goes through and finds these individuals who are wielding power in ways the president disagrees with, he is, by and large, constitutionally entitled to eliminate their positions. And if he thinks the Constitution empowers him to do that, even if the Supreme Court has said with respect to other past employees or past officers that person couldn't be removed, he has the right to fire them, and they can bring a challenge, and we can work it out that way. With respect to regulation, departmentalism, I think, makes it far easier to deregulate than to enact regulations in the first place. And the reason for that is I'm probably in the burn it all down camp. Not all of it, but most of it. I wanted to bring a chainsaw, but Lisa said I couldn't expense the gasoline. It's very expensive. No, much of what the federal government does, it does not have the constitutional authority to do. Again, under the actual Constitution, not the one that the Supreme Court and Congress have invented over the years. And the president's entitled to make that determination and entitled to say this regulation, and he would usually be right, or this expenditure that Congress has passed under a spending clause that you will not find in the Constitution, is unconstitutional. And so I have not only do I have a right, but I have a constitutional duty, my fidelity to the Constitution, to eliminate that regulation, to deny, to not further spend in violation of the Constitution, and so on and so forth. And that gives an entity like DOGE, whatever it is, a lot of leeway, in my view, to stop the unlawful expenditure of funds, or just to eliminate funding he doesn't like, frankly, because most of it's unlawful, or to eliminate regulations. So I'm sensitive to the concern as like a Burkean conservative that there's a risk if you move too fast, you make mistakes. But I think what people need to realize is there's two types of mistakes, like false positive and false negative. So this is famous in the FDA approval context for drugs, that the errors in a false negative, where they approve a drug that ends up being dangerous, that's really, really obvious to everybody. They approve this drug, it goes onto the market, and a whole bunch of people get sick or die. What's less obvious, but equally severe, are the false positives, where they keep a drug off the market, and because of that, all these people are dying of conditions that could otherwise be cured. It's the same concept here, where yes, going quickly could lead to mistakes. You could fire people who shouldn't be fired. You could eliminate spending that shouldn't be eliminated. You can eliminate regulations that shouldn't be eliminated. But what I would suggest is the last approximately 100 years of American history, we have not moved nearly fast enough. Nearly every time we try to get rid of, to deregulate, to eliminate agencies, to do any of that, we fail. And so the only plausible way of getting that done, if you think it's important, as I suspect many of us do, is to probably err on the side of eliminating too much. And that will have negative effects. But again, not moving fast enough also has negative effects in the form of an immense administrative state that imperils our liberty, that is bad economically, that frankly is acting contrary to the Constitution that the people administering those agencies are supposed to be bound to effectuate. Whether Elon Musk is an officer was Judge Cole's question.
Glad you got to it at some point.
Yeah, all right. So I can stop. I mean, I'm skeptical he would count as an officer under the original understanding of that phrase. I don't think he even holds an office, is one problem. I think it's more of an informal advisory role. But I'm hesitant to answer this because I actually don't know like what DOGE is completely, or how it's, like where it's housed and what he's doing and what position he holds and what he actually does. How much, like, to what extent is he sort of the person out in front promoting this stuff? To what extent is he actually the one making the calls? I just don't know the answer to that, so I don't have enough information to say.
All right. Well, thank you. And I think you see there's sort of a range of views here, but a concern that Ben raised, and I might rephrase a little bit, but I'd be interested, Bridget or Susan, in your take on it, is both of you, I noted in your opening remarks, said we concede that reform is needed here. There definitely should be reform. And I think there may be some people, maybe even some people in this room, who would say, yeah, that's DC speak for let's talk this to death and then that not ever really change anything, right? When people say, well, right, we definitely need to change things. We 100% agree. We need to have first a commission to study it for like 3-4 years, and then we should probably come together and have a drafting committee, draft some proposals, and then probably if you gave us about, 8 to 10 years, we could come up with some and then nothing ever changes. And so there's that famous saying, move fast, break things, from Silicon Valley. I think it probably started. But if you don't do that, how does reform ever happen? And you say, yeah, we have to be careful, sure, but we may be approaching a fiscal cliff, or we may have other problems that we need to address. How do we do that consistent with the process concerns that you're raising? I just welcome your thoughts.
Yeah, I think that's an excellent question. And it's one that I ask myself because I've been in Washington a longer time. I've been involved in these things than most people in this room. And there's always been an interest in reform, and the regulatory state, the administrative state just keeps getting bigger. So I actually, maybe I'll turn that into a question. I mean, part of my concern or my worry is you can break some things, but if it's not done in a durable way, any executive order that you sign, the next president will revoke. president who disagrees with you will revoke. And so it's not lasting. How do you make these things lasting? So if you don't mind, I'll ask Ben a question, because, and I think you maybe answered this, but on the, if the president thinks that a regulation is unconstitutional, either because it didn't interpret the law correctly or is somehow, can he revoke that without going through notice and comment? And what happens then if he revokes it and somebody sues? Yeah, I'm just curious how that works out, because this is something that I've had smart lawyers tell me on both sides. One is can't be done, others who say, I think maybe it could.
So I think it depends what you mean by revoke. I think if it's eliminated from the Code of Federal Regulations, no. I think then he has to go through the APA process, because Congress has enacted that law to regulate the way in which the regulations are promulgated, including their elimination. But what he can do is say, and this is the way that's less durable, is my administration has concluded that this is unconstitutional. It will not be enforced. And at that point, there could be a challenge, of course. Someone could bring a lawsuit, and then there could be a judgment that he's actually bound to follow. Yeah, I think it's unfortunately, I don't think there's a way for the president to eliminate the regulation from the CFR without going through the APA process.
Yeah, Bridget?
Yeah, I mean,
But give it a try.
so I guess I would say, governing's hard. I think anyone who's been in a position of having to be in a governance role, whether it was for a local chapter of something or a national organization or even elected to office, or if you're running an office, right? Governing is hard. It sometimes takes a lot of conversations. Allow me to just reintroduce the idea of the Madisonian principles of the legislative process, right? It wasn't meant to be fast, but it was actually intended to be deliberative, slow, calculated, one that brings in lots of different voices, right? And what DOGE and this president are not doing is bringing Congress into the conversation. Now you could say, look, that's because this Congress isn't going to do it, right? The president knows what's what. What I don't understand, though, is what this means for the future. If the idea is it's all unilateral action all the way down, it's all presidential power, right? And we just allow Congress to decide when it's going to get into the game, that doesn't comport with my understanding of the rule of law. So Article 1 needs to get into gear here, right, and play its constitutional role in a more significant way. Might it take them a while to get to settlement on reform on all manner of topics? We know the answer is yes, but that's not a bug. That's a feature of the system that our framers put into the Constitution. So for me, the fact that we don't always get immediate reform that's comprehensive on every issue that we'd wish for doesn't mean that we don't have to go through the steps. And so there's a certain amount of petulance of just saying, I'm just going to do it. Right? And it's not only President Trump that has sort of reached for that lever. We've been through, as long as I've been a professional, right, we've been in an era of maximal presidential power and pushing the boundaries more and more. But there's a fundamental lack of humility with that approach, and an unwillingness to go through the steps that our framers laid out for us in the role of Congress.
Yeah, can I weigh in on that? Because I partly agree. You're right about the Madisonian Compromise, and you want this deliberative process for legislation. And that's why if what DOGE does is purports to undo legislative acts, there'd be a problem. I don't think that DOGE can't eliminate an agency. The president can refuse to staff it. He can say these various acts it does are unconstitutional, and I will instruct my subordinates not to do them. But he can't literally eliminate the agency. For the most part, CFPB might be an exception because they have control over the funding.
But it's not just CFPB, right? It's multiple agencies right now that have been, even if they still exist on paper, fundamentally zeroed out.
Right, and so I think that, though, is permissible. The problem with it is not as durable because the agency's still there and can be restaffed. The next president may disagree with it. But the other point that I think is equally important is that much of what DOGE is responding to is not legislation passed by Congress. It's executive actions that did not go through that deliberative bicameral process. It's supposed to be hard, and they're getting rid of those regulations. The reason our regulatory state is so large, or one reason why, is because that gridlock that is a good thing that our Constitution creates to stop the passage of legislation was deemed to be inconvenient in the early to mid 20th century. And so we created this rule-making process. The executive is making the rules. And without the checks and balances to stop that, you had this explosion of regulations. And so insofar as they're getting rid of that, they're really not operating counter to that Madisonian compromise. I think they're, if anything, honoring it by getting rid of these rules that bind private citizens that didn't go through that process.
Well, Ben, I'd like to pick up and ask a question. I guess that takes the question I just asked and flips it a little bit and picks up on your comment about those of us who are Burkean at heart, right? And so whatever we might think about the legality of anything that's going on, sort of the magnitude of some of these changes has been pretty dramatic and sweeping and acting at a pretty fast pace. And I use the phrase move fast, break things. And you might say, yeah, that's great when you're dealing with a tech company. All the stakeholders sort of know their risk exposure. If you don't want to be overly exposed to that risk, you diversify your portfolio. Shareholders are limited in what they can lose. If the company goes bankrupt, they only have whatever they've invested. The employees can go find new jobs. There's multiple companies all trying to do the same thing. So moving fast has benefits, and we can be risk neutral because there's a lot of participants in this particular market. I'm not sure, does that map onto the government? There aren't great alternatives necessarily if something goes really wrong because of moving fast and breaking things. It turns out we broke something important. I mean, what's your sort of response to a Burkean point about we can't be risk neutral when we're talking about the government like we could be if we're talking about investing in a startup? Yeah,
I mean, I think my response is that we've given the Burkeans 40 years since Reagan to try, and they've utterly failed, and things have gotten worse, if anything. And beyond that, the administrative state has gotten more out of control than ever. When you look at things like the OSHA vaccine mandate or some of the stuff the EPA was doing, where they're taking narrow grants of authority that did pass through the legislative process and using that to at least attempt to exert immensely broad control over private citizens, there is a very serious threat to our liberty that I think we don't appreciate because it's there all the time. So again, it's like that air where people are dying from the condition because they're not getting the drug, but you don't realize the drug's available. And so, yeah, it's good to move slow and be deliberative, but we tried that, and Reagan made it a little better. First Bush made it worse. Clinton made it actually maybe a little better than Bush did. The second Bush made it far worse. Obama made it even that much worse, maybe a little bit better under Trump, and then Biden was a whole new world of abuse. And so, at some point you have to say that this isn't working anymore, and we have to try something more drastic, or nothing's ever going to change. I just don't see how there can be what the other solution is at this point.
Yeah, and we're getting close to where if people have questions, you might want to start lining up with the mics. But so I think what you're saying, Ben, I don't want to simplify it too much, but you're sort of saying not to decide is also to decide, right? I mean, to not take action is to let the current inertia continue towards it. If we're headed for a cliff,
yeah, I think what I'm saying is that a lot of this probably depends on your view of how dangerous the administrative state is. If you think the government's generally acting in good faith and doing a pretty decent job, then it probably doesn't make sense to move fast and break things. But if you have the view that they're radically undermining our constitutional order and are in many cases maybe not meaning to be, but acting contrary to American interests, then it's worth moving fast and breaking some things, a lot of things.
Can I
sure.
pick up on something
Sure.
both Bridget and Ben said? So Bridget talked about the DOGE we want versus the one we have.
Well, your mileage may vary. Yeah.
So the DOGE I would want is one that forced a real look at what's working and what isn't. Speaking of businesses, the reason you can move fast and break things is there's a feedback loop, and you can learn and you can pivot and move quickly. Whereas, that's much harder, and we never look back when it comes to regulations. We're always looking ahead to the next regulation we should issue. So we just build that stock of regulations as each new president, including President Trump, his last time, he issued a lot of new regulations, as did Bush in Bridget's and my day. So there's always some new new thing to regulate, and it's not nearly as cool to go back and look, well, did we really achieve what we said we were going to achieve? Whereas you could never do that in a business environment. So we kind of need that. So that would be the DOGE I would want. And it would go back to what are the core government functions and what can marketplaces do? So Ben's examples of like the OSHA vaccine mandate, why is that something the federal government needs to do? So if DOGE could do that and just focus on what really should be left to private markets and individual decisions versus where are the core things, like Bridget talked about, some of the, safety nets for your Head Start program for low-income families. Are there ways that we could figure that out? So we'll see whether I get the DOGE I want or not.
Very good. Well, yeah, you may. Sure.
Just a question before we get to the questions. I guess the one element that I don't think we've sort of foregrounded in this is what happens to something like trust when you break things in the manner that DOGE is breaking them. So if you had a government contract to do X, the government backs out of it. It's a separate question whether it's the government's legal right to break a contract. Another thing is like investments were made, people were hired, people moved across the country for certain jobs, and rather than unwinding things in a way that tries to cope with the complexity of what's going on, just these guillotine falling cuts really limit the ability for folks to trust that if, for example, something that you care about ends up in the category of something that this administration is willing to say, hey, we maybe acted a little bit fast there, let's go ahead and call you back in, i.e. folks running nuclear safety, i.e. scientists running Parkinson's studies, for example. Is it really a switch you can flip back on, right? Or once you've stopped a Parkinson's trial, is that trial basically flushed down the drain because you acted so quickly that basically your data's garbage now? Right. So it's not the case that you can just flip the switch back on and all of these, oh, oopsie, we made a mistake and fired a bunch of people that we shouldn't have, right? Real harm, real lives can be at stake, which for me is why the move fast, break things, one of the reasons why the move fast, break things approach to government fails, right? And that the idea that we need to be more deliberate in how we wind things down, how we go about handing things off, right? Stopping multi-year data collections on the fly, right? Saying we're simply not going to do that anymore ruins that data forever, right? It's gone, right? So like there is not a way to just turn things back on. This is not Twitter, right? You can't just relaunch that set of code and make it live and everything goes back to good. It is not a timeline. This is real life.
Bridget, yeah, question?
Yeah, I have a generic question about what's going on and the credibility of actually the Federalist Society. I've been a member of the Federalist Society for 7 to 10 years or so, and I think it's a great organization. It's done great work. But I really think the next 4 years are going to be the defining years of the Federalist Society. I consider myself a conservative Reagan Republican. And I think, but I don't consider Trump a conservative. They talk about rhinos. Well, I want to start talking about sinos, conservatives in name only. I really don't think Trump is a conservative, or I don't know what he is,
So
ideologically.
the question is?
Yeah, the question is, all this stuff's going on, and we as conservatives need guidance as to how far off the track this stuff is. I mean, how can the president just withdraw money from universities because he doesn't like their DEI program? I mean, is that a slam dunk from a legal standpoint? As someone who hasn't taken the time to study that, how can he eliminate the Department of Education unilaterally?
Right. Well,
that doesn't. I mean, on any level, it doesn't make any sense to me. Yeah. How can he be withdrawing funds on a lot of things where it's already pre-authorized from Congress? Mm-hmm. And so anyway, this is my question. As a Federalist Society, we don't take positions on specific issues, but we do study specific issues. And I really think in the next 4 years, as a member of the society and continuing supporter of this society, I'm very interested in how serious we're going to take the analysis of how he's unilaterally exercising power. I mean, a lot of this stuff they're doing by the seat of their pants. I mean, they're coming up with theories that I mean, just by the seat of their pants. How in the world can they possibly think they're going to bring the federal government waste under control in a year and a half? They haven't even gotten to the Defense Department. So anyway, my question is,
I'm starting not to believe you, but okay.
and I would be interested and I'd be happy to talk to you afterwards. Are any of you concerned as a conservative that we may be, in the next 4 years, being basically complicit in letting Trump pull out a lot of this crap and we're not proactively challenging it? Because I really don't even have the time to read.
I think that may be beyond the remit of this panel. I'm not sure if you were asking the conservatives in the room.
DOGE.
I mean, look,
It's very relevant to DOGE because these guys are just doing things. I like a lot of what they're doing.
So I'm the president of the Columbus chapter. Federalist Society is a pretty big tent. You get the conservatives, you get libertarians, and even within those groups, you have people who have idiosyncratic views. So I don't think you're going to, if the group can't and won't take a position on particular issues, what we do provide is a forum to debate the things you're talking about, which is what we're doing now. And I think in some cases, some people are going to think they went too far. In some cases, they're going to say they didn't go far enough. And there'll be disagreement and debate, and then hopefully that informs your view.
Thanks. So did you have a question, and maybe shorter, a little shorter?
I'm joking. I actually have a question. So it sounds, from the discussion of the panel, it kind of sounds like it's almost DOGE or nothing. And I'm not sure that's exactly the case. So I was just kind of curious if there were suggestions from the panel about potential alternatives for those who are perhaps anti-administrativists, things that could be done, instead of just chainsaws and things like that. So I know at Ohio, at the state level, we have 5-year retrospective reviews. We have executives that are asking for a percentage of regulations to be eliminated. Are there things that maybe could be taken from the state level that could be applied at the federal level? And if it's not DOGE, are there other things that, maybe more conservative or libertarian or Reaganite or whatever term you'd like to call people, could do, whether that's sunsetting or retrospective review or things like that? Thank you.
Susan or Bridget?
Yeah.
Short ideas? Yeah.
I would say, absolutely. There's lots we can try. There's lots really where the states have been leaders in trying different approaches to, like structural approaches, I suppose, to the challenge of figuring out the right amount of regulation for this or that. So I think, it's not that there's no playbook here. What we saw in the first Trump term was a regulatory 2-for-1, and now we see them going with a regulatory 10-for-1 with important caveats. They've carved out immigration rules this time around because it was a real drag when they had to do the accounting for that in the first term, right? So they've just said, let's go ahead and save ourselves the trouble, right? So, what it looked like in the first Trump term was very much, I would agree with Susan's characteristic of it being something of an accounting gimmick, right? That's not structural reform. Press releases aren't structural reform, right? You actually need to dig in.
Does structural reform have to come from Article 1, or could there be structural reform within Article 2?
Article 2's been trying for as long as we've been in this space, right, Susan? What do you think?
Yeah, and I think there's more Article 2 can do. That my DOGE wish list was probably broader than DOGE, but I also think Article 1 needs to step up to the plate. We saw bipartisan support. We saw real deregulation in the 70s and 80s, mid-70s to mid-80s, under President Carter, President Reagan, and even before them. That was bipartisan, across the branches of government. I tend to think that it was economists who kind of showed that those regulations were really harming consumers and harming the economy. And then policy entrepreneurs moved with that. I would love to see something like that, but I really despair.
Yeah. Question?
Well, I was just going to say, in response to the question about states, I just want to echo something Justice DeWine said earlier, which, and to your point, I think I'm agreeing with you that the federal government should be looking to the states because they have 50 laboratories where they can see what works and what doesn't. And a great example of that is the elimination of Chevron deference. There were over a dozen states across the political spectrum, across geographically disparate, that eliminated their version of Chevron before the Supreme Court did. I don't think the court discussed it. Kavanaugh asked about it at argument, but I do think seeing how it works on the ground and that the world didn't spin off the axis is something that will matter both to legislators and to the courts. So states should be experimenting with this stuff, not only for themselves, but because it can have a national impact.
And related to that, federal government shouldn't be issuing rules that are one-size-fits-all regulations that could be handled better by the states.
Yes.
Now that the executive is essentially like devitalized itself and removing itself from these overbroad powers that's granted itself over the decades in the administrative state, what tools or changes does the Article 1 power need to potentially gain or reassert itself to address maybe the vacuum that might create?
So I don't think the executive's really claimed much power for itself. I think Article 1 is willingly given it away. And I think and part of it is that problem with refusing to acknowledge that they too have a duty to respect the Constitution. But Article 1 has immense power. I mean, Article 1 can, everyone agrees, eliminate these agencies, eliminate these programs. They have complete control over the spending. So I don't think there's any doubt that if we had a Congress that would take its constitutional duty seriously and actually saw this as a problem, then they would act. Now, what I'll say is I think many of the people in Congress like to say it's a problem. They might even believe it's a problem on the ground, but politically it's much, much easier to just delegate all this stuff and let the executive branch figure out what the rules are going to be, and then, well, don't blame me. I didn't elect the president. The president just did his own thing. I didn't pass that law. So I think that's part of the challenge, and part of the reason you see so much delegation is because it's very politically convenient to let someone else handle it.
So incentive structure-wise, how do you change that, though? I mean, if model politicians as people who want to get reelected, give them a mechanism to offload responsibility for, statutes that are passed. How do you flip the incentive structure to make them want to exercise that authority?
Will Loper help? I mean, did it require the courts to say, Congress, you can't keep doing this because we're not going to buy it?
I mean,
Am I dreaming?
Well, they could still have delegations is the
Right.
problem.
Right.
Like
They get the delegations. I mean, I don't mind being a little cringe and idealistic on this point. I mean, I think it's reasonable to expect legislators to want to deliver results for their constituents. So if you actually want to build something, if you actually want a program to function for your constituents, you go to Congress and you try to make it work. I mean, there ought to be some self-interest there. So to some extent, it's us as voters, demanding accountability from our elected officials and sending them to Washington or to the State House to do what we want them to do.
Yeah, I think it's got to ultimately come from the voters because that's what their self-interest. That's what will motivate the legislators. I mean, the problem is our Constitution is an incredible document. It's a brilliant work, but it's predicated on one premise that turns out not to be that true, which is that each branch will vigorously enforce its own prerogatives and really resist any encroachment by the other branches. And that may have been true early on, but it pretty quickly became not true. And it's definitely true with respect to this problem. And so that's kind of baked into the Constitution, unfortunately. That said, what's also baked into the Constitution is that those legislators are ultimately responsible to the people. And so if there were enough interest in getting this done, then you'd see effects in Congress. Now, that's a much harder project and will take a longer time, but it doesn't mean it's not worth doing.
Yeah, and what do you do with it? And I don't know if it's still true, but I remember there was a time when it was true that you could run polls and everybody liked their own congressperson and hated Congress, right? And so what do you do? Because people like their own legislator. They think they're not the problem. It's the body that's the problem, right? And so I don't know how that gets implemented.
I think there's a fair number of people who might think that their legislator is a problem, right? So in that sense, I do think the Trump administration has the potential to be an accelerationist, right, towards more voter engagement. And we've seen in some of these special elections, turnout's pretty high. Salience of these issues is pretty high. It's not how I would choose to juice voter engagement, but here we are.
I mean, one quick thing is the judiciary has a role here too, and I think reinvigorating the non-delegation doctrine is something I'd like to see others need to push. I don't know if the court has the appetite for it, but I think it is consistent with it. That doesn't mean what it looks like is up for debate. But if Congress is giving away power it's not constitutionally authorized to give away, then the courts have the ability to say so when presented with a case that question arises in. And there's plenty of good test cases out there if you look through the U.S. code.
But as a good departmentalist, should Article 1 listen to what Article 3 says?
Well, they can keep passing laws, so they don't. I think they're free if they think they're constitutionally entitled to do that, to continue to pass these laws. And of course, the executive is free to enforce the law that was deemed unconstitutional, except with respect to the judgment that was issued. But in practice, what's going to happen if the Supreme Court says this delegation is unconstitutional? Is I think that agency will cease operating generally, just because the executive won't want to keep litigating that case by case by case.
Yeah, question.
If Judge Cole will permit, I have an intra-panel question, as long as that's not along beyond the scope. And that was, Ben, I wondered if you might respond to the comments made in the previous panel about rogue prosecutors who many of the panelists said were violating their oath by, one of the examples was not seeking death penalty cases. And in light of what you said about, every actor needs to make their own decision about upholding the Constitution, would you agree that, if an elected prosecutor believes that pursuing the death penalty would violate the Constitution, does that classify as someone who's violating their oath of office?
If they actually believe that, and then no. I think if they did believe that, it would be so egregiously wrong that the other branches would be free to exercise their constitutional prerogative to remove them from office. Not based on their a lack of fidelity to the Constitution, but based on just or not based on an intentional lack of fidelity, but based on an actual infidelity to the Constitution. So yeah, I that is, especially when you have a divided executive like states do, where in the state very clearly the executive power is not all vested in one office. It's really spread out, not only at the state level, but then 88 in Ohio, 88 separate county prosecutors. I actually don't know what the impeachment rule, but let's just say the General Assembly had an impeachment power for county prosecutors. The county prosecutor has a duty to independently assess what the Constitution requires, but the legislature does too. And if the legislature determines he's acting contrary to the Constitution, they could remove him.
Thanks.
Yeah, question?
Yeah, thank you. I had a question related to a statement made by Professor Dooling related to the loss of trust on the cancellation of these contracts, people reordering their lives, and then, oops, we screwed up. We actually do want that contract. It was my understanding that those contracts, or many of them, had the provision, one of the clauses was that the government could cancel for any reason or no reason. Is there any federal limitation on just not putting that provision in a new contract to renew that?
Not like having a new contract without that provision?
Right.
That keeps the government bound to it?
Right.
I don't know, honestly. I mean, I think that's probably a federal procurement question. But I think that, folks contemplating entering into new deals to provide the government with services or to receive grant funding from the government would rightly be very wary, right? Can they really rely on it being there? I don't know. I mean, I think that right now that trust has been pretty well broken. So I think that is going to cause a whole cascade of reordering that we're only just starting to get a glimpse of. And as to whether, you can draw up a contract that doesn't have that kind of unilateral out for the federal government. And I should be clear that not all these contracts have that, right? I mean, these things are being canceled in such a way that it is not at all clear that they all possess that clause to begin with. On grant funding, on terminating federal employees and saying that it's because of performance, but it turns out their performance evaluations were fantastic, right? So there's a lot of fast and loose, let me use a better word, unlawful activity happening, right? And so the courts will catch some of that. They won't catch all of it. And in the meantime, folks are going to move on and go about their lives, right? So I've wandered rather from your question. I don't know the specific answer.
Okay. And with the room full of attorneys, I think that just sounds like fodder for lawsuits, right? If these contracts are being canceled without
and as we know in this room, probably better than most, litigation isn't free. So it's simply not the case that everybody who lost their job unlawfully is going to have the bandwidth to do anything about it. And we've seen some movement towards classes, right? So treating employees as a class, but not everybody. And so some cases are being sort of handled, at least on a personnel level, right? Go one by one to the Merit Services Protection Board, which may or may not be able to act on them, on and on. So we have at this moment something of a remedies challenge, right? And whether the equitable remedies that can be offered are actually up to this moment, where you see this amount of extensive lawlessness.
We do have a court of claims judge in here somewhere, Judge Holt, who might have better information about how you bring the breach action. But
Yeah.
Thank you.
Yeah, but I'm maybe more broadly on that. I think there's some recognition that reliance interests matter, right? And you don't have to dig too far into law and economics and contract law to realize that, generally speaking, rewarding reliance interests allows for contracting, allows for mutual gains through trade and things like that. Are you concerned? I mean, Ben, you're sort of, I guess, the bigger advocate for move fast, break things. Are you concerned if one of the things that gets broken is reliance, that it is going to increase overall contracting costs on a going forward basis if there's sort of an unrecoverable reliance damage?
yeah, I mean, so part of the problem is that I don't really want people who research like testosterone levels in transgender dung beetles to be able to rely on those grants. Like, it'd be good if they couldn't, and then they wouldn't seek them anymore. But in terms of people who provide actual valuable services, like military contractors and things, yeah, that's a concern, and that's why I can't responsibly defend every single, because I don't even know what they are, every single action that DOGE undertakes. But I think on net, approaching the waste of federal funds pretty aggressively, even if it leads to some upsetting of reliance interests, is worthwhile. And I think I guess there's some areas where you can be pretty confident the reliance interests you're upsetting are things that would be good to upset.
Charlie?
Thank you to the panel. My name is Charlie Olerman. To my reckoning, what has fueled the interest in the kinds of activities and reduction of waste, fraud, and abuse being undertaken by DOGE, what's fueled that is the tremendous overspending by the federal government. Deficits $2 trillion per annum as far as the eye can see. And that in turn to me begs the question, what are we going to do, or what can be done to change the structural incentive for legislators to overspend their means, our means?
Well, I can say the way I don't
If we
think...
fix that one today, that's going to...
Yeah, no, we're going to do it in 5 minutes or less. I mean, I can say that one way that I don't think we can fix it, right, is through a president that doesn't honor the appropriations that he's been given and a prior president has signed into law. I don't think it's the case that the president should be able to simply decide not to spend that which Congress has ordered him to spend. So I wouldn't argue for that way as a way to rein in, the choices that our legislature is making. As to other ways, I will yield my time.
Yeah, I don't know. Make the legislators personally liable.
Yeah.
Other than that, it's again, I think it goes to that point about the Constitution was ratified expecting that there would be this check on that each side would vigorously enforce its own powers and resist encroachments. And a lot of that expenditure comes when they're giving away authority to particularly the executive branch.
Well, I think you get the last question, so it better be a great one. It's the last question.
I'm gonna do my
of the
best.
whole day. All right, Maurice.
So I think it ties together all the other questions in that how much of this goes back to the fact that Justice Sutherland was the last great justice of the Supreme Court, in that that New Deal era, that progressive New Deal era, was when this reflexive doctrine of judicial deference took the judiciary's hands off of controlling or in any way evaluating the spending clause. You talk about reliance interests, but the court around that time shredded reliance interests by abolishing the obligation of contracts clause in Blaisdell. And one by one, all of the safeguards and checks on all of the problems that we're talking about were just sort of shredded from the progressive era, beginning with the Wilson appointees through FDR's appointees. And we just sort of let that deference concept ride. And when conservatives saw the Warren Court, they decided that actually deference is good now because we don't want the creation of new rights. So our endorsement of that deference doctrine and refusal to revisit some of those New Deal era mistakes when beforehand things like the Social Security Act and Agricultural Adjustment Act, were found unconstitutional as overspending. How much of our refusal to revisit that progressive New Deal era is really the core source of the problems we're just rearranging the chairs on today.
I have to weigh in.
I'm shocked.
Justice
Okay.
Sutherland wrote Humphrey's executor. He's disqualified from being a great justice. I checked that just to confirm it before I said it. Look, I think the court has done too little to enforce the limits under Article 1 in particular, and in a lot of the ways you suggest. I also think it's a mistake to put too much hope in the courts because they are the least powerful branch, and they will not win the battle. Like, if they're correctly interpreting the Constitution and the people are mad enough with their rulings, the Constitution is going to get amended, or Congress is going to pack the court. So that doesn't mean they should change the way they do things, but I think it's a fantasy to think that if the court just starts taking the Constitution seriously enough, seriously again, that will be enough. I think unless you have the other branches bought in, then you're still going to have problems. And we need to get the other branches bought in.
Bridget, Susan, last words?
No.
Metaphorical. Oh, okay.
No. I think my only last word is that when it comes to thinking about hope and trust and where to place it, I place it where I always have, which is with the people. And so, we'll see what happens next. But in the meantime, maybe we go drink some wine.